She didn't answer me, but I told her.
Hello, this is Tina with tournament staff. If you all could test your microphones and your cameras and just make sure everything is working, the judges should be on their way in momentarily.
And they can begin whenever they're ready to go. Worried about Dr. Flores.
All right. Looks like everybody's working here. Can you guys test your microphones out?
Are you all able to see and hear me okay? Awesome.
Can you all see and hear me?
Can everyone hear me? And can everyone hear me? Can everyone hear me?
All right. Yes, great. Thank you so much. We will see the judges in here in a moment and we'll be able to begin momentarily. Congratulations to everybody and good luck.
Hear me?
Yes, I can hear you, Mike.
Great. Louis, where do we see the okay, I got it. I see the ballot.
I was actually just about to ask the same question.
It's underneath, it says, you see the room status on that side. Just
Yes, I did. Yeah.
go down, you'll see it.
Okay.
Hi, everyone. This is Tina with tournament staff. It appears everybody's cameras and microphones are working well. So whenever you all are ready, the live stream is ready. And so you're good to begin.
All right, everyone is ready. I'll be the clerk for today's round. And just to confirm, Mr. Rangel, you will be the Chief Justice for today, correct?
I believe that the Chief Justice is Mike Ferris.
Okay.
Mike, is that?
That's fine with me. That's fine with me. Yeah.
All right, so, all right. In that case, oh yay, oh yay, oh yay. The Supreme Court of the United States is now in session. The Honorable Chief Justice Ferris presiding. All those having cause to be before this honorable court, draw nigh and pay heed. God save the United States, and God save this honorable court.
All right. Ms. Kavanaugh, am I correct in thinking that you're the first speaker for petitioners?
Yes, Your Honor.
All right, you may begin.
Thank you so much, Your Honor. Mr. Chief Justice Ferris, Honorable Associate Justices, and may it please the court. My name is Hannah Kavanaugh. My co-counsel, Ali Satterfield, and I represent Mr. William Denolf, the petitioner in the case at bar. At this time, I would like to reserve 3 minutes for rebuttal.
That's fine.
Thank you so much, Your Honor. My co-counsel will be addressing the issue of the 8th Amendment. First, I will be addressing the 5th Amendment issue. It is our contention that Mr. William Denolf's 5th Amendment right against self-incrimination was violated during the administration of the functional brain mapping exam, the FBME, for 2 main reasons. First, because Mr. Denolf meets the 3-prong test this court established in Fisher versus United States, as cited in the United States versus Hubble. And second, the police officer's neglect to read Mr. Denolf's Miranda rights constitutes a clear 5th Amendment violation. The first issue that petitioner would ask the court to consider today is the 3-prong test written in United States versus Hubble and then from Fisher versus United States, which writes, quote, to qualify for the 5th Amendment privilege, a communication must be testimonial, incriminating, and compelled, end quote. Thus, in order for Mr. Denolf to qualify for the 5th Amendment privilege, all 3 prongs of this test must be met. Both the petitioner and respondent agree that the information obtained was incriminating, as page 11, paragraph 3 of the fact pattern indicates. The only remaining questions before you today are of the following two prongs. As the first, Schmer versus California clearly delineates how this test is testimonial in nature. While this case dealt specifically with a physical test, procuring a blood sample to determine the blood alcohol level of petitioner Schmerber, the majority noted that, quote, to compel a person to submit to testing and which effort will be made to determine his guilt or innocence on the basis of physiological responses, whether willed or not, is to evoke the spirit and history of the Fifth Amendment, unquote. This clearly...
Counsel,
Yes, sir.
what if he kept a diary, an accurate diary of everything that was said, or that he did on this particular occasion, did and said? Would it violate the Fifth Amendment to get his diary?
It would violate the Fifth Amendment if they were using the content of that diary. That
Okay. Go ahead.
Absolutely, Your Honor. I was just saying that as referenced in the footnotes of Pennsylvania versus Muniz, this court has addressed the issues of handwriting exemplars. And they talk about how the physical attributes, the physical nature of the script can be used, but not the content of the script.
But could you get the diary with a warrant?
You could get the diary of the warrant, yes, Your Honor.
If there was a warrant issued for this test, was there not?
Yes, Your Honor.
And so what do we make of the warrant? I mean, I know that the Fourth Amendment was not raised and this is a Fifth Amendment concern, but are we on the right amendment? I mean, should this be a Fourth Amendment concern and not a Fifth Amendment concern?
I would think, Your Honor, that it should be a Fifth Amendment concern. While I do think that examining this from the perspective of a Fourth Amendment lens would be interesting, we are unfortunately limited to just examining it from the Fifth Amendment. And we
Why is that unfortunate? I don't understand why it's unfortunate.
I was just saying, Your Honor, that it would be interesting to examine it from that perspective. I'm not saying that it wasn't a violation of the Fifth Amendment or that it would be a less powerful violation for us to examine. I was merely commenting on Chief Justice Ferris's question.
Let's with respect to the challenge that's before us, do you read this to be, are you bringing a facial challenge or are you bringing an applied challenge? Is the FBME always unconstitutional or just under this set of facts? And if it's under this set of facts, why? What did the police do that was wrong?
It was an applied challenge in this particular case, Your Honor. And what the police did that was exactly wrong is first the specific nature of this test when you combine it with the other two factors. The FBME in and of itself doesn't create compulsion, testimonial, and incrimination. However, when you combine those three prongs, we see the information obtained was incriminated. The FBME,
So you can see that it could be constitutional and other sets of facts?
yes, it could be constitutional, absolutely, in other sets of facts, Your Honor.
So what is the error what's the exact error that the lower court made?
Well, he was compelled, and this particular, it was a testimonial act. We would contend that the FBME is testimonial, but it isn't
How
inherent.
was he compelled? They said we would like you to take a test. They walked with them. He wasn't in handcuffs. He could have gotten into a taxi. He had his wallet, etc. They never chained him down. How is it compelled?
It was compelled for a very specific reason, because in order for valid consent or full and knowing consent to be present, an individual must know of all possible options in a given scenario. And the absence of proper Miranda safeguards denied Mr. Denolf the knowledge he needed to make that fully informed and consensual decision you're talking about, Your Honor.
But Miranda only applies to a custodial interrogation. If it's not custodial, what's the harm? And not only, as Justice Ringgold said, I think he was told that he could walk away at any time. Was he not told that? Basically, you're not in custody if you're free to leave. Isn't that the standard?
Well, Your Honor, we would disagree that Miranda versus Arizona only applies in custody. That was found in the case of Pennsylvania versus Muniz, in which the lower court's decision was affirmed. And the lower court concluded, quote, when the physical nature of tests begins to yield testimonial and communicative statements, the protections afforded by Miranda are invoked, end quote. This defines that Miranda...
I'm just curious, Ms. Kavanaugh, maybe I'm looking in the wrong place. I don't see Miranda cited in the list of cases.
Miranda versus Arizona was cited in Pennsylvania versus Muniz, Your Honor, as well as Estelle versus Smith.
So your argument rests on a case within Munoz, basically?
As a case cited in Muniz, yes, Your Honor. And it's cited in numerous other cases as well, because Miranda versus Arizona is one of the most fundamental cases in the Fifth Amendment regarding knowing consent and defining the parameters in which we know or do not know. Basically, what kinds of things needed to be told to Mr. Nolf in this instant case.
Okay, I want to go back to your case that you say that changes Miranda from custodial interrogation. So, I mean, I'll just assume for the current purposes, Miranda only applies directly on its own force to custodial interrogations. What case do you think modifies that?
Pennsylvania versus Muniz, Your Honor.
What court decided that case?
The Supreme Court decided
When?
that. 1990.
And what did they say in that case? What did
In
we
that-
say in that case?
What the Supreme Court said in that case, Your Honor, they were specifically referencing whether or not the drunken utterances of a man could be considered constitutionally protected. And in that particular case, they were 8 questions that they asked Mr. Muniz. 7 of them were considered routine booking questions.
Well, in Munoz, we held that if a question reveals your state of mind, that's where the Fifth Amendment is implicated. Booking questions, no. But if the question, and I think that's the point you're making. So let me just, in response to your answer, which again I think is correct, how does this test reveal his state of mind? He didn't say anything. He doesn't say anything. How does it reveal his state of mind?
Yes, Your Honor. While you are absolutely correct in asserting that the facts of the record make it clear that he didn't say anything, this court has also made it clear that you don't just need to say something for it to be considered a testimonial communication. This was seen
Where?
in Doe versus United States, Your Honor, where they hold that testimonial communications are all that, quote, relate a factual assertion or disclose information. This
Now, Mr. Doe loses that case, so that's kind of dicta, right?
I'm not.
Okay, is this the bank case? The bank record case?
Yes, Your Honor.
Okay.
Yes, and this is just a definition that they established. It wasn't particularly regarding whether or not Mr. Doe was compelled or whether he acted in a testimonial way. It was establishing a definition of what testimonial communications mean.
Are memory thoughts, Ms. Kavanaugh?
Yes, Your Honor. Your Honor, I see that my time has expired. Is it okay if I briefly conclude, Chief Justice Ferris?
10 seconds, yes.
Thank you so much, Your Honor. And it's for the above reasons the petitioner would respectfully request that the ruling of the 12th Circuit Court of Appeals be overturned.
Thank you, counsel. Okay.
Permission to proceed, Your Honor?
Certainly, Ms. Satterfield, you may proceed.
Thank you. Mr. Chief Justice, Honorable Associate Justices, may it please the court. My name is Allie Satterfield, and I, along with my co-counsel, Hannah Kavanaugh, represent the petitioner, Mr. William Denoff, in the case at bar. Today, I'm specifically addressing the violation of his 8th Amendment rights. There was an egregious violation as the punishment he received goes against the evolving standards of decency that ought to mark the progress of our maturing society. And furthermore, Poseidon Penitentiary has blatantly disregarded and willfully ignored pressing threats toward Mr. Denoff's health and welfare. And it is for these reasons that we ask this court to overturn the lower court's decision. In Trop versus...
And the concept of originalism.
Excuse me, Your Honor. I did not hear the first part of your question.
Do you understand the concept of constitutional originalism?
Yes, Your Honor. And in Greg...
Okay, so my question is, how is the theory of involving standards of decency consistent with the standard of originalism? Maybe some justices on the court that aren't originalists that would be interested in the evolving standards of decency. I'm not one of them. I'm an originalist, and I want to know how the treatment that your client received was cruel and unusual in light of the original meaning of the 8th Amendment.
Certainly, Your Honor. Well, we can look to the historical implementation of solitary confinement, and it does date back to the 1820s. However, Your Honor, Olympus is the only jurisdiction that uses solitary confinement as a form of punishment for crimes committed prior to entering the prison system. And when the framers of our Constitution were establishing the 8th Amendment, solitary confinement at that time was not being implemented. So it would not be in front of them to consider that issue. And in Gregg versus Georgia, this court dealt with a similar matter, weighing whether or not the death penalty was per se unconstitutional in light of society's evolving standards of decency, but also in light of how the original framers of the Constitution were viewing it in terms of the 8th Amendment. And while they conceded that, yes, they would have thought that the death penalty was permissible, that it wasn't enough to simply look to what our founding fathers would have said, but also to how society has gradually progressed over time. So by weighing both of those together, we can truly discern whether or not a punishment is cruel and unusual under the meaning of the Eighth Amendment. And at the time, once again, solitary.
I'm sorry, Ms. Satterfield, I'm just curious. You say that Olympus is the only state that has a judge put this sentence in place, specifically with solitary confinement, based on what you did before you joined the prison population. How do you address the fact that in a number of states, a large number of states, if you're in a gang, you're segregated when you go in, that you might be put in solitary confinement because you're in a gang? How does that differ? Or how do you reconcile that statement?
Certainly, Your Honor. Well, there are two reasons that I would say that it differs from the facts at play in the instant case. First being that gang members are automatically sentenced to solitary confinement in 30 states, and that is because of potential dangers they see, the prison staff sees with them joining together and causing harm to other inmates as well as prison officials. So it is an automatic sentence, not one that a judge is specifically imposing as a punishment for a particular crime. It is just because they were affiliated with the gang. But
why is it worse for Eighth Amendment purposes that a judge makes the decision rather than prison officials making the decision? It would seem to me that it would be better to have the judge who heard the case to be making these kind of decisions. And I don't see any basis for saying the Eighth Amendment draws a line between judges and people who work for the warden of the penitentiary.
Certainly, Your Honor, and we would contend that that is because of Solem versus Helm, as is cited in Ewing versus California, where this court established that there are three relevant factors to determining if a punishment is actually usual. And the third and final prong being the examination of how inmates are sentenced for commission of the same crime in other jurisdictions. So even if we allow gang members to be automatically sentenced, that is for commission of a different crime than what Mr. Denolf did. In the instant case, he was sentenced to solitary confinement because he tortured and murdered his victim.
Did he receive the sentence that's common for people in Olympus who commit the same crime that he committed?
Your Honor, according to the footnotes, approximately 100 prisoners in Olympus are serving their time in solitary because they tortured their victim. However, the facts of the record do state that not all inmates who tortured their victims were sentenced to solitary confinement, but the majority of them are.
It's the majority, right?
It is the majority.
How can a sentence that is practiced by the majority of the states be unusual?
Well, it's not practiced by the majority of states, Your Honor. That data was specific to Olympus.
Solitary confinement is not practiced by a majority of the states?
Oh, solitary confinement is, Your Honor. I beg your pardon. I specifically meant the majority of inmates who torture their victims. That data was specific to Olympus.
John, how is my fault? How is, if solitary is practiced by the majority of the states, how is it, before you turn to cruelty, how is it unusual?
Because, Your Honor, we are not facially challenging solitary confinement as a whole. If it is going to be used as a last resort or for administrative or disciplinary reasons on inmates while they are already spending time in prison, it can be a necessity to implement that form of punishment. But we are not addressing whether or not solitary confinement can be used at all, but rather in the instant case, how it was specifically used, because it was an unusual sentence for commission of a capital murder, compiled with the fact that it was cruel because of Poseidon Penitentiary specifically and their deliberate indifference towards the severity of mental health harms that solitary confinement brings about.
Counsel, with respect to the question I have is if he was evaluated by the prison officials when he got there, and they looked at it, at the crime that he committed, and said, this guy is going to be a danger to whoever he's with. And they said, you're in solitary for the entire time of your term. Would that be any different? Would that be okay for Eighth Amendment purposes?
No, Your Honor, because in Estelle, Well, in Estelle versus Smith, they cited the American Psychiatric Association Task Force on the Clinical Aspects of the Violent Individual, and they contended that the psychiatric community are of the opinion that predictions as to whether a person would or would not commit violent acts in the future are of fundamentally very low reliability, and that even psychiatrists possess no special qualifications to make such predictions.
Well, why gang members then? I mean, I'm sure you can find a study someplace with some psychologists who'll say, you know, treating all gang members in that way is arbitrary and capricious. Why is it any different?
Because there is an imminent danger of the gang members reassociating with other members of the same gang. So rather than them coming together and being one unit that is dangerous to the prison population as a whole, they are isolated and separated for that reason, because there is reason to believe practically that that's going to happen.
Okay, so
Ms.
you're not contending then that the problem is that the judge sentenced him to to solitary confinement for 30 years rather than a prison official making that determination.
Your Honor, I see that my time is about to expire, so may I answer your question briefly?
You can answer my question, yes.
Thank you very much. Your Honor, I am not contending that there would be any difference between the judge or a prison official determining if Mr. Danoff needed to go into solitary confinement. If it was a prison official determining after he had already been incarcerated that he was in imminent danger because he had a shank or had made threatening comments, then that would be a separate issue. He could be put into disciplinary housing. But if it was just an arbitrary presumption, then no, that would not be okay.
Thank you, counsel. All right. All right, Mr. Clark, are you ready to proceed?
Yes, Your Honor.
All right.
Thank you.
Yep.
Mr. Chief Justice Ferris, Honorable Associate Justices, and may it please the court. My name is Christian Park, and I stand to represent the respondent, the state of Olympus, along with my co-counsel, Lucas Spencer. Mr. Spencer will be addressing the Eighth Amendment issue, but first, I will be examining the Fifth Amendment claim. Now, petitioner claims that the FBME test is intrusive and that it violates the defendant's right to protection from self-incrimination. In order to prove this false, we look to the very standard proposed by opposing counsel, the case of Fisher v. United States as cited in Doe versus United States, where this court held that in order for petitioner to successfully prove that there was a Fifth Amendment violation, they must be able to demonstrate that the evidence was compelled and testimonial. We respond to those issues with two lines of argumentation of our own. First, the evidence provided by the FBME was not compelled. And second, the evidence was physical, not testimonial. If we are able to prove
it's
this,
not compelled when there was a court order, a warrant authorizing the search.
absolutely, Your Honor. The facts of the record do delineate that a warrant was obtained. However, that warrant wasn't necessarily to force Mr. Danoff into taking this FBME test, but rather to use the
This is Tina with tournament staff. If you're an observer in here, can you please switch to ncfca.org/live? Thank you so much. And those of you who are coming back in the room, can you turn your cameras on so that we can check on you?
Okay, before we proceed again, okay, Justice Ringgold is not back yet. But I can ask Mr. Parker, the time is not running at this point in time. I'm going to authorize you to add 30 seconds to your time because of the inherent disruptive nature of what's happened. And so you get it right from now, an extra 30 seconds so that we can get back into the swing of things.
And
Thank
can
you
I
very
just
much, sir.
clarify, the last thing I heard was Mr. Park say something about Fisher cited in Doe. And so I don't know if there was anything after that, but that's last time.
Could you just repeat what you said about Fisher? Time has not yet started, but just to help us get reoriented, what was the last thing that you said about Fisher and Doe, please?
Yes, Your Honor. Opposing counsel set a standard established in Fisher versus United States, which is cited in Doe versus United States, where this court held that in order for petitioner to demonstrate that there was a Fifth Amendment violation, they have to be able to prove both that the evidence was compelled and that that evidence was testimonial in nature. If we
Okay,
as respondents are, yes, Your Honor.
that's good enough. Turn your clock back on and we'll begin.
Yes,
All
sir.
right.
I'm ready whenever.
Okay, go ahead. Well, let me just ask you a
Yes.
question, because I asked you about the warrant, and I want to hear more about why you think it was not compelled. If his appearance was subject to a court order, I don't see how in the world, or the progress of the exam was subject to a court order. How can anyone contend it's not compelled?
Absolutely, Your Honor. Mr. Denolf was not compelled because he was never shown the warrant. When we look to the facts of the record, it never states that the police came to Mr. Denolf's door, showed him the warrant, and said, "You have to come with us." Rather, according to page 4,
A search warrant of his premises. It's a warrant basically to search his brain, isn't it?
yes, Your Honor. But something very interesting to note is that
He wasn't shown the warrant?
no, Your Honor, nowhere in the facts of the record does it tell us that Mr. Denolf was shown the warrant.
Does
Moreover,
it say that
according
he
to
wasn't
page,
shown the record, that he wasn't shown the warrant, or is it just silent?
it's silent, Your Honor, which I'm sure we can assume that he was never actually shown this warrant
I don't think
because
he
the
was-
warrant wasn't.
Because that, I mean, if you want to make an argument on the fact that he was not shown the warrant, and therefore it's not compelled, the state's lawyers have the duty to get that in the record.
Your Honor, I would like to first start off by clarifying what the warrant was specifically used for. I don't believe the warrant was actually used to force Mr. Denolf into taking this test. Rather, the warrant was obtained in order to use the functional brain mapping exam. When we turn to page 4, paragraph 4 of the
Let's
facts.
suppose that the warrant was acquired, so there'd be no Fourth Amendment violation. Okay, but that still leaves us with the Fifth Amendment, right? Now, the FBME, as I understand it, if I hold up this, your brain knows, generation difference or not, that this is a mouse, right? And if I hold up this, you know it's a highlighter, right? Given how the FBME works, doesn't it inherently compel you to answer the question, whether it's a verbal question or otherwise? Doesn't it inherently compel you to answer?
Yes, Your Honor. The functional brain mapping exam may perhaps compel you into giving an objective answer to the abstract question that the FBME asks. However, I would like this court to note that Mr. Denolf himself is the one who put himself in that situation.
But Mr.
So for
Park,
example,
the test, as I understand it, correct me if I'm wrong, is it incriminating? Okay, I think that's a slam dunk for petitioner. Is it compelled, and is it testimonial, right?
yes,
It
Your Honor.
sounds to me like you've just conceded that it's compelled. So how is it not testimonial?
Your Honor, we would actually respectfully disagree that it isn't compelled, because with a blood draw, for example, if an individual chooses to put himself in a situation where his blood is drawn, the blood will compel the blood draw will compel him or give the police an objective answer to the question, was he drunk during the time that he was arrested? So what we should
ask him the question, and not violate the Fifth Amendment. Were you in the motel room? And we're going to assume that it's compelled. But the question is on the testimonial nature of it. Were you in the motel room? Is that testimonial or not?
Your Honor, if Mr. Denolf was asked the question, are you in a hotel room, and then Mr. Denolf communicated a response, that would be testimonial, Your Honor. But that isn't what happened.
It's basically jiggling a switch in your brain to make you answer that question in a nonverbal manner, but answer it you have, right?
Perhaps, Your Honor. However, we would contend that the means of actually obtaining an answer to the question is purely physical. When we look to page 3, paragraph 2 of the facts of the record, the FBME is not a mind-reading device. The police aren't able to ascertain actual memories through the use of the test. All they are able to determine is whether or not the flashes of the brain are there. The brain is a physical.
I agree with you that it doesn't determine if you like something or don't like something. So he didn't recognize Trump Tower. That doesn't tell me that he approves or disapproves of former President Trump. I agree with you there for certain. But he recognized the Hotel California and the room that this crime had been committed in. You're telling me that's not a memory? Recognizing something's not a memory?
No, Your Honor, it is a memory. However, the FBME doesn't take that memory from Mr. Denolf. It uses cognitive functions. It uses, or rather looks at the. Yes, Your Honor.
Who did they get it from if they didn't get it from Mr. Denolf?
They did get it from Mr. Denolf, Your Honor. However, I'm talking specifically about the process of the FBME. The FBME isn't a mind-reading device because they aren't able to know whether or not Mr. Denolf committed the crime through the use of the test. They don't see the exact memory.
Admitted into court. I thought both sides stipulated that this thing actually works. And the thing that it works, it tests the question, does he have a memory of this scene? And the answer is yes, he has a memory of this scene. And both of you have testified that it's accurate. If that's not the case, the evidence is not admissible. It's the same as a lie detector test then. It's just, well, your brain did some waves, and so what? Lie detectors aren't admissible because they're not proven to be reliable. You guys have stipulated that this is reliable. I don't see how you can contend it's not testimonial.
Actually, Your Honor, we would argue that that's exactly what delineates the functional brain mapping exam from a lie detector test. A lie detector test isn't 100% accurate because it relies on subjective aspects such as the rate of your heart or the rate of your
Wait,
breathing.
so
So you are
it's-
able to.
there's no Fifth Amendment violation because it's accurate, because it's a 100% accurate?
No, Your Honor, there is no Fifth Amendment violation because the FBME doesn't take testimonial evidence. With a lie detector test,
Is the
you're able
evidence
to
physical? Is the evidence physical?
Yes, Your Honor, we would argue that it is because all the FBME
How?
does
How is it
record,
like the blood? How is it like a blood test, Mr. Park? How is it physical?
because it looks purely at the body, Your Honor. In a blood test, it looks at the blood, not anything within the mind. In Doe versus United States, this court defined testimonial evidence as evidence that is coming directly from one's mind. Now, I'd like to delineate before this court
Where's
the
your mind?
mind and the brain.
Okay, go ahead. I want to hear this.
Yes, Your Honor. The brain is fundamentally different from the mind because the brain is a physical aspect of your body. The mind is more abstract. And in Doe versus United States, this court explicitly held that evidence that is coming directly from one's mind may be unconstitutional. But if evidence is coming from a part of your body, that is purely physical evidence.
Okay,
And when we look to the physical,
if the test said your brain was composed of 3% fat, that would be a physical test of the brain. But what we're talking about here is, does your brain have a memory of a particular event? How do you describe that without being in your mind?
Your Honor, the FBME does not intrude upon the inner sanctums of one's mind because, again, when we look to the facts of the record, when defining the functional brain mapping exam, all it does is look at the physical neurological flashes of the brain. Perhaps that information.
In final examination or in final argument, I guarantee if we go back and read the record, the chief prosecutor argued he was in the room, he recognized it from this exam. We know he was in the room because his mind recognized it or his brain recognized it. If that's the nature of the final argument, which I guarantee you it is, how in the world do you have a case?
Again, Your Honor, I would have two responses. My first response is we would have a case because when we look at the direct process of the functional brain mapping exam, it's not extracting the memories themselves. It's using physical aspects of the brain to determine whether or not the memory is there. My second response to the question, Your Honor,
it's that it takes it away from you, you can't get it back. I mean, what do you mean it's not extracting? It's revealing it, right? It may not permanently remove it from him, and you can hold it in your hand, but you've learned what he thinks, right?
No, Your Honor. The FBME does not reveal a single thought. It doesn't reveal Mr. Denolf's memory of committing the crime. It only is able to determine whether or not the image that is shown to him is familiar. And the way it is able to ascertain that information is by looking at the physical brain. It does not intrude upon the inner sanctums of his mind.
Well,
For these
Counsel,
reasons, we
let me
ask.
butt in for just a minute. I'm
Yes, sure.
sorry, I've been pretty quiet till now. With the results of the FDME by themselves, and I'm sure Chief Justice Ferris is going to give you plenty of time to finish up. Would the results of the FDME by itself have any meaning to a juror, or does it require expert testimony to interpret the data to have some meaning for a juror?
Yes, Your Honor. Chief Justice Ferris, may I answer the question?
You may.
Thank you, Your Honor. Yes, Associate Justice Clayton, it is true that interpretation is necessary, but we would argue that the same is with the blood test. If we conduct a blood draw, by purely just looking at the blood, we aren't able to determine whether or not there is alcohol samples within that blood. Interpretation is still necessary, but just because interpretation is involved doesn't mean that that evidence is immediately testimonial. We are looking rather at whether or not the evidence is coming from the mind itself. And the functional brain mapping exam doesn't do that. It looks purely at the physical aspects of the brain. So because, Your Honor, we argue that Mr. Denolf was not compelled, and because the evidence was physical, not testimonial, we urge this court to affirm.
Justice Clayton, because of the interruptions, if you'd like to ask a follow-up question, go ahead.
Nope, that's fine. We can move on. Thank you for your time.
Okay. All right. Mr. Park?
May I proceed, Your Honor?
Yes, you may, Mr. Spencer.
Thank you. Mr. Chief Justice,
Mr. Chief Justice, Associate Justices, and may it please the court. My name is Luke Spencer, and I rise to continue argumentation on behalf of the respondent, the state of Olympus, in the Eighth Amendment claim. As the government, we understand that certain people, such as the petitioner, hold the opinion that Mr. Danoff does not deserve his punishment. Simply put, their opinion holds no weight. As a matter of fact, Your Honors, my opinion holds no weight. The key opinion which does hold weight are the people within Olympus. This idea was echoed in the case of Harmland v. Michigan on page 998, paragraph 2, in which they explain, we have no idea of what happened on the streets of Detroit, but the members of the Michigan legislature do. Likewise, we have no idea of what happened on the streets of Nur, but the Olympus legislature does. We'd ask this court to affirm the Olympus Supreme Court's decision and find that the punishment given to William Danoff does not violate the Eighth Amendment. To this end,
if the people in Nur, Olympus, concluded that the right answer to overtime parking was to serve 50 years in jail, and the parking is a really bad situation in Nur. Would that be okay? Would that violate the Eighth Amendment, cruel and unusual punishment for overtime parking?
Your Honor, it is not the respondent's stance that the state of Olympus can do whatever they please, but rather that this court should give large deference to the state of Olympus and their legislature, as we've seen in the case of Ewing v. California, where they explain that this court has had a long history.
Great deal of deference, and the way you posited your argument was nobody has any right to say anything about it except for the voters and the legislators of the state in question. So what are the limits to your argument then?
Your Honor, it is merely my contention that the state should have a presumption, this court should have a presumption in favor of the government, and that the petitioner has the heavy burden. And we would contend under our second point that the petitioner fails this burden. Would you like me to get to my second point?
Where do you get the presumption against your client, or against the private individual? Where does that come from? What case?
Your Honor, Greg v. Georgia on page 20, paragraph 1 explains that a heavy burden rests on those who attack the judgment of the representatives of the people. Furthermore, that's
not an Eighth Amendment standard. That's just a general presumption of constitutionality of legislation. Was that an Eighth Amendment case where you got that from?
It is an Eighth Amendment case, and even if it was a general standard, we would contend that it still applies in the instant case because the state of Olympus still stands up for the people within Olympus. It's also important to note the holding of Weems, United States, as cited in Harmland on page 993, paragraph 1, where they explain that when a sentence is imposed within the limits of a statute, it will ordinarily not be regarded as cruel and unusual. Furthermore, the state of Olympus is not punishing Mr. Danoff wantonly without reason. I'm going to pause my timer really quickly because my headphone has just died and I am unable to hear all of you. So if you give me one moment, I need to go change up my headphones. I'm so sorry.
In the Mike and everybody else in the national championship round on Zoom the second year, when my student Marco Romero was arguing, the Chief Justice's audio cut out during her question. And Marco just guessed at what the question was, and he fortunately guessed correctly. And I think it actually in some ways helped. So it's not just, the Zoom stuff happens or whatever platform we're on. It's just the world we're in now. And so, Mr. Spencer, I doesn't bother me that happened.
Mr. Spencer, you may carry on.
Yes, Your Honor. Thank you, Your Honor. Furthermore, the state of Olympus did not punish Mr. Danoff wantonly or without reason. Page 13, paragraph 6 of the majority explains that the state has a valid interest in special deterrence. Numerous cases from Ewing to Harmland v. Michigan have established time and time again that deterrence is a legitimate penological aim. Foreman v. Georgia, as cited in Harmland on page 1028, paragraph 3, explains that criminal conduct is so...
How to deter him anymore that he's in solitary rather than he's in prison?
Your Honor, in regards to the idea of proportionality, I'd point this court's attention to the primary holding in Harmland v. Michigan.
Proportionality is relevant to deterrence. Let's stick with deterrence. That's your argument. I want to hear what you have to say about deterrence.
Your Honor, it is...
Sorry.
It is my contention that the necessity of solitary confinement should not be taken into consideration. Harmland v. Michigan says that the Eighth Amendment does not pertain a proportionality guarantee, only forbidding sentences that is grossly disproportionate to the crime. So
Yeah, I don't
regardless of
the difference between deterrence and proportionality. And so let's try it again. Deterrence means he isn't going to do this anymore. Proportionality, it weighs the relative harm. It's like putting people in jail for parking tickets. That's disproportionate. You don't, that's way too heavy of a punishment for a parking ticket. And so are you or are you not relying on deterrence as a justification for this sentence?
Your Honor, deterrence is the justification provided by the state, and it is our contention that even if
My question
deterrence,
is, how does this prevent deterrence?
Your Honor, the goal of a penological justification is not necessarily the effectiveness of it, but what they are trying to achieve. And I would contend that it is not on this.
You can have goals that are, what if their goal was that, they want to make the state a better, I mean, that's not making any sense, counsel. If the goal has to be realizable, if you have a goal that you're never going to get to, what good's the goal?
Your Honor, I point this court's attention back to Ewing and Harmland v. Michigan, and that established that deterrence is a legitimate penological aim.
Okay, I got that. I agree with that. But we're not determining whether the guy's in jail or not. We're determining whether he's in solitary confinement or not. And if deterrence is all you've got, you're going to lose. You got to have something more than deterrence. And I would suggest you go on to the next thing.
Okay, Your Honor. So on page 13, paragraph 6 of the majority, they actually state that the state has 3 different versions of penological justification, that being retribution and incapacitation. And we would contend that solitary confinement also upholds these 2 penological justifications. Now, opposing counsel referenced
I agree with you. My question is a little bit more specific. Why does it need to be a minimum of 15 years to incapacitate him? Why? Petitioner did not get to Helling, bring in Helling, and I don't know if that would have been Petitioner's argument. We spent a lot of time on usualness, but let's suppose that we look at this through the Helling lens, and you've got objectively cruel, subjectively cruel, and of course then it has to be unusual. Seen from that perspective, why couldn't you achieve incapacitation without a minimum of 15 years?
Your Honor, we would contend that the length of a sentence imposed has no matter in today's court hearing. Roma v. Estelle, as cited in Harmland, explains that the length of a sentence imposed is purely a matter of legislative prerogative and therefore should not
Mr. Spencer, with respect to your references to Harmland, do you have a case with a majority opinion where because that's in a part of the opinion that had no majority. Is there a majority opinion of this court where we've said that we're going to let legislatures do whatever they want?
Your Honor, I do not have a case referring to the majority, but I would contend that this should be persuasive on today's court because legislatures, as seen through numerous case precedent, should have deference.
But then, Mr. Spencer, if legislatures can do anything they want at any time, then what is our role here?
Your Honor, it is not my contention that legislatures can do whatever they want. It is my contention that a punishment can be cruel and not necessarily unconstitutional. And this actually leads me to the unusualness of solitary confinement. Now, opposing counsel contended that this
before you go there, if I can just clarify, because again, my question, which I really don't think you've answered, is why does it have to be 15 years? Isn't that subjectively cruel? You don't let the warden take him out of solitary confinement for a minimum of 15 years. Are you conceding it's cruel, as was done the case in Harmland, and just explaining why it's not unusual, or will you please address my question?
Your Honor, and in this instant case, we would actually agree that the punishment is cruel, but we would contend that it is not unusual and therefore it is not unconstitutional. The argumentation opposing counsel used to prove this punishment's unusualness is that the state of Olympus is the only state that allows judges to sentence inmates to solitary confinement. But we would like to make a delineation between the method of punishment, aka the sentence, and the actual punishment. Page 7, paragraph 2 of our Constitution forbids cruel and unusual punishments. Page 6, paragraph 3 of our record explains that 20 other states allow for unlimited length solitary confinement as a punishment. And so although the way in which Mr. Danoff has received this punishment may be
Well,
abnormal,
Mr. Spencer, what you say is certainly accurate. How do you reconcile that with the approach we've taken with in cases where we've looked at trends? How do you reconcile what you're saying with respect to that?
Your Honor, I believe you're referencing the case of Solem v. Helm, and according to Harlan v. Michigan, the third prong provided in Solem v. Helm on page 990, paragraph 1, does not have any relevance to the Eighth Amendment. And so the trends used through states, according to opposing counsel's case of Solem v. Helm, would not actually apply in the instant case because it was overturned by Harlan v. Michigan.
Well, in the dissent, it states, if I'm not mistaken, that 20 states have proposed ideas to move away from this. 7 states have already banned solitary. And correct me if I'm wrong, and that no single state has expanded its use in the last 15 or 20 years, right?
It appears I've ran out of time. May I briefly answer the question, Mr. Chief Justice Ferris?
Absolutely.
Your Honor, solitary confinement may have less use, but we would still contend that society has not been moved past solitary confinement due to the large usage still within 20 other states. For that reason, we would contend that although solitary confinement may be cruel, it cannot be considered unusual. For that reason,
if we look at trends and not the overall raw number, do you lose?
Yes, Your Honor, but as Chief Justice pointed out, we are looking at the original intent, not per se the trends per se. Thank you.
Thank you.
Thank you, counsel. All right, which of you are doing your rebuttal?
I am, Your Honor.
All right, Ms. Satterfield, you may begin.
Thank you very much. Mr. Chief Justice, Honorable Associate Justices, the petitioner wishes to offer 2 lines of argumentation in rebuttal. First, in regards to the Fifth Amendment. Mr. Danoff was indeed compelled. He could not have consented because he wasn't aware of all of his options under the framework of Miranda. And pursuant to Pennsylvania versus Muniz, when the physical nature of tests begins to reveal testimonial or communicative statements, the protections afforded by Miranda are invoked. Mr. Danoff was never informed of that third and final prong of Miranda, that what...
You're getting some echo. I apologize for that. No one's asking you a question. Continue.
Oh, sorry. That what he said and did could and would be used against him in a court of law. Furthermore, it was testimonial. In order to satisfy the court's standards for what is testimonial, pursuant to Doe versus United States, we do not need to prove that officers were able to see the exact picture of Mr. Danoff murdering Ms. Somerville. We only need to prove that this conduct required his consciousness of the facts, which page 3, paragraph 2 of the facts of the record make clear that the FBME requires Mr. Danoff's memory in order to function. And with this in mind, I wish to proceed to the second line of argumentation in regards to the Eighth Amendment. The punishment he received was both cruel and unusual. Now, opposing counsel contended that it was not an unusual punishment and it was not cruel because there were penological justifications. However, I would wish to point this court's attention to Trop versus Dulles, in which that case dealt specifically with the court outlining that the punishment he received under the 1940 Nationality Act was to serve the penological justification of deterrence. However, the court contended that that was not constitutional, even though it was penologically justified. Why? Because it was still cruel. Thus, even if you believe that the punishment he received was penologically justified, that does not mean it's permissible under the scope of the Eighth Amendment.
Counsel, I have in mind your good answer relative to the originalism thing, but on the trends of the case, there is case law that supports your position that the trends on Eighth Amendment matters, the evolving standards of decency, do get this court's consideration on a regular basis. But my concern is, how do we measure that? I mean, is 20 enough? Is 20 that have looked at it and 7 have done it? What's the tipping point of that standard? How do we implement it, and how should it be implemented here?
Well, Your Honor, I see that my time is about to expire, so
My question.
thank you very much.
Because I talked too long. Go ahead.
No, you're perfectly fine, Your Honor. Well, we would contend that there does not need to be an exact number of states, but rather we should look to the general progression of society as a whole. In Thompson versus Oklahoma, this court outlined that we ought to look to states. We also ought to look to expert opinions on a particular punishment, as well as how other Anglo-American countries that share our heritage and Western democracies implement punishments and what they say about them, because there certainly must be a level of empirical data to show that a punishment is truly harmful. It also must be shown that states are moving away from utilizing that punishment and that other Western democracies have also condemned a punishment. All of those are present in the case at bar. It is cruel pursuant to expert testimony in Porter versus Clark. Other nations, according to the facts of the record, mainly the UN, have condemned it as torture. And according to page 20 of the fact pattern, states have since 1998 only adopted laws limiting or banning its use. So society is progressing away from it. And that is why we would ask this court to overturn the lower court's decision. Thank you.
Thank you, counsel. All right.
The honorable court is now adjourned.
I believe that we leave the room. Is that correct, Caleb?
Yes.
Do we return for comments after we've done our ballots? Is that the protocol?
No, I don't believe so.
Okay, all right. Y'all did great.
Thank you, Your Honor.
Yeah, I don't think that we get to give any verbal feedback. If you want any from me, other than what's in the ballots, people who run this know. You guys, both teams did a terrific job. I've got a couple small things that might help people, but I need to do my ballot. So relax. Congratulations to everybody.
Thank you.